with reference to the questions which we had formulated, and thereafter with reference to the submissions made by all the learned council. These are the three major issues, or rather three major points for determination formulation as to whether reservation is an instrument for inclusion of socially and educationally backward classes to the mainstream of society, and therefore reservation structured singularly on economic criteria violates the basic structure of the Constitution. B, as to whether the exclusion of classes covered under Articles 15.4, 15.5, and 16.4 from getting benefit of reservation as economically weaker sections violates the Equality Code and thereby the basic structure doctrine. C, as to whether reservation for economically weaker sections of citizens up to 10% in addition to the existing reservations results in addition of basic structure on account of reaching the ceiling limit of 50%. These points for determination have been dealt with reference to the relevant constitutional provisions, doctrine of basic structure and constitutional amendments. Thereafter, the segments of the judgments are expanding doctrine of equality, affirmative action by reservation, exception to the general rule of equality, economic disabilities and affirmative action, whether economic criteria as sole basis for affirmative action violates basic structure, EWS reservation not availing to certain classes, whether violates basic structure, breach of 50% ceiling of reservations and basic structure, and then there are other factors and summations. After having dealt with these aspects, the conclusions are as follows. For what has been discussed and held here in above, the points formulated in paragraph 31, I just read that, are answered as follows. Reservation is an instrument of affirmative action by the state so as to ensure all-inclusive march towards the goals of an egalitarian society while counteracting inequalities. It is an instrument not only for inclusion of socially and educationally backward classes to the mainstream of society, but also for inclusion of any class or section so disadvantaged as to be answering the description of a weaker section. In this background, reservation structured singularly on economic criteria does not violate any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India. B, exclusion of the classes covered by Articles 15.4, 15.5, and 16.4 from getting the benefit of reservation as economically weaker sections, being in the nature of balancing the requirements of non-discrimination and compensatory discrimination, does not violate Equality Code and does not in any manner cause damage to the basic structure of the Constitution of India. C, reservation for economically weaker sections of citizens up to 10% in addition to the existing reservations does not result in violation of any essential feature of the Constitution of India and does not cause any damage to the basic structure of the Constitution of India on account of breach of the ceiling limit of 50% because that ceiling limit itself is not inflexible and in any case applies only to the reservations envisaged by Articles 15.4, 15.5 and 16.4 of the Constitution of India. Not much of the contentions have been urged in relation to the impact of the amendment in question on admissions to private unaided institutions. However, it could at once be clarified that what has been observed here and above in relation to the principal part of challenge to the amendment in question, read with the decision of this court in Pramati Trust, the answer to the issue framed in that regard would also be against the challenge. Accordingly, and in view of the above, the answers to the issues formulated in these matters are as follows. One, Third Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions, including reservation, based on economic criteria. Two, the 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution by permitting the state to make special provisions in relation to the admission to private unaided institutions. Three, the 103rd Constitution Amendment cannot be said to breach the basic structure of the Constitution in excluding the SEBCs, OBCs, SCs, STs from the scope of EWS reservation. Consequently, the transferred cases, transfer petitions, writ petitions, and the petition for special leave to appeal forming the part of this batch of matters are dismissed. Our acknowledgements while closing on this reference, sincere thanks and compliments deserve to be placed on record for the learned counsel for the respective parties, their associates and their researchers, and also all the constructive contributors whose erudite and scholarly presentation of respective viewpoints has rendered invaluable assistance to this court in shaping the formulations herein. Thank you.
I'll now invite Honorable Justice Bela Trivedi to place her view.
I have concurred with the opinion of Brother Justice Maheswari. However, have penned down certain my views also. I'll just read them out. As well settled, it must be presumed that the legislature understands and appreciates the needs of its own people. Its laws are directed to the problems made manifest by experience, and its discriminations are based on adequate norms. Therefore, the constitutional amendment could not be struck down as discriminatory if the state of facts are reasonably conceived to justify it. In the instant case, the legislature, being aware of the exclusion of economically weaker section of the citizens from having the benefit of reservations provided to the SCs, STs, and SCBCs citizens in clause 4 and 5 of Article 15 and clause 4 of Article 16, has come out with the impugned amendment empowering the state to make special provisions for the advancement of EWS other than the classes mentioned in clause 4 and 5 of 15 and clause 4 of Article 16. The impugned amendment enabling the state to make special provisions for EWS of citizens other than SCs, STs, and SCBCs is required to be treated as an affirmative action on the part of the Parliament for the benefit of and for the advancement of the EWS of the citizens. Treating EWS of citizens as a separate class would be a reasonable classification and could not be termed as unreasonable or unjustifiable classification, much less a betrayal of basic feature or violative of Article 14. As laid down by this court, just as equals cannot be treated as unequals, unequals also cannot be treated as treated equally. Treating unequals as equals would be as well offend the doctrine of equality enshrined in Article 14 and 16 of the Constitution. The SCs, STs, and backward class for whom the special provisions have already been provided in Article 14, 15.4, 15.5, and 16.4 form a separate category as distinguished from the general or unreserved category. They cannot be treated at par with the citizens belonging to the general or unreserved category. The impugned amendment creates a separate class of EWS from the general or unreserved class without affecting the special rights of reservations provided to the SCs, STs, and SCBCs. Therefore, the exclusion from the newly created class for the benefit of EWS in the impugned amendment cannot be said to be discriminatory or violative of Equality Code. Such amendment could certainly not be termed as shocking, unconcernable, or unscrupulous travesty of quintessence of equal justice as sought to be submitted by learned counsels for the petitioners. The sum and substance is that the limitations that is substantive or procedural imposed on the exercise of constituent power of the state under Article 368 could not be said by any stretch of imagination to have been disregarded by the Parliament. Neither the procedural limitation, that is the mode of exercise of amending power, has been disregarded, nor substantive limitation, that is the restricted field, has been disregarded, which otherwise would invalidate the impugned amendment.
Right. EWS verdict has been upheld in the top court. At least 3 out of 5 judges have favored it. And Meenakshi joins us live on the broadcast. Meenakshi, take us through the